Hi, and welcome to the next video in the housing module. This video will be taking a look at eviction prevention and how you can help a client avoid an eviction. We're going to start by going back to the 5-step eviction process and taking a look at some of the best ways that you can help a client depending on which stage of the eviction process they're in. After that, we'll cover some common types of evictions and things that you can do to help a client depending on which type of eviction they're experiencing. In our last video, we covered the legal eviction process in Ontario. There are 5 key steps in this process, and we're going to take a look at each of these again to see how you can best help a client depending on where they are in the eviction process. Let's start at step 1, the notice of termination. The first thing that you can do is tell your client that they do not need to move out if they don't want to. This notice is only step 1 in the process, and it doesn't require your client to move out right away. The next thing that you can do is review the notice with your client and help them make sure that all of the information on it is correct. You can also help them identify the type of notice and what it means. Some notices can be canceled or voided if your client takes certain steps, but we'll talk about those a little bit later on. The last thing that you can do is make sure that your client is aware of the termination date listed on the notice. Your client doesn't have to move out by this date, but if they choose to stay and don't take steps to void the notice, their landlord can file an application with the Landlord and Tenant Board, putting them into step 2 of the eviction process. If this happens to your client, the first thing that you can do is remind them that they do not need to move out just because they received a copy of this application. You can also help them check the status of their eviction online. You can do this by finding their Landlord and Tenant Board file number on the application and inputting it into the board's online file status tool. This will tell your client some important information, like the date and time of their hearing, and whether or not an eviction order has already been issued by the board. If your client received an application to evict from their landlord, they should have also received a notice of hearing. You can review this notice with them, and make sure that they're aware of the date of the eviction hearing, and understand the importance of attending. You should also be referring your client for legal advice well before their hearing date. As we know from the 5-step legal eviction process, the eviction hearing is step 3. At their eviction hearing, your client should come prepared to explain to the board everything that they want them to know before they make a decision about whether or not to evict them. And you can help your client get prepared by doing some key things. The first thing that you can do is help your client write down their version of the events. Talk to your client about the eviction and ask them what happened. You can also help them make note of any circumstances that might be important for the board to consider. This can include things like if they were in custody, if they had money stolen from them, if they lost their job, or if their income support was reduced or cut off. Your client can also talk about things like how long they've lived in the unit, if they have kids living there, if they have a disability, or if they're low income. This kind of context is important and can be powerful at an eviction hearing, so it's important to have these facts summarized ahead of time. Another thing that you can do is help your client gather any evidence that they want to present to the board. This can include things like letters, receipts, bank statements, canceled checks, repair estimates, or pictures of damages and things that need fixing. This type of evidence can help offset a landlord's position and help your client avoid an eviction. But they will need to share these documents with the board and their landlord ahead of the hearing, so it's best to organize them as early as possible. The last thing you can do is help your client make a plan for the day. If the hearing will be in person, you can help your client organize things like transportation, childcare, or time off from work. If the hearing will be virtual, make sure your client has access to a reliable and secure internet or phone connection. Ideally, they should also have a quiet and private place available when it's time for their hearing. If your client still hasn't received legal advice ahead of their hearing, you should refer them to the Tenant Duty Council. This is a free legal service provided by the Advocacy Centre for Tenants Ontario. On the day of the hearing, you can also make a plan to support your client. You can either attend with them at the hearing or arrange for another support person to attend with them. You can also prepare your client by outlining the process and letting them know that after they tell their side of the story, they might be asked questions, but they'll also be given an opportunity to suggest a solution. It's important when having these discussions with your client that you do not tell them what to say or what to do, because that would be considered legal advice. If your client is unsuccessful at their eviction hearing and the board issues an eviction order, they'll be in step 4 of the process. Remember, even if the board issues this order, your client's landlord is still not allowed to change the locks. Only the court enforcement office, also known as the sheriff, is allowed to do that. If your client has received an eviction order, you can do one of two things. If the eviction order is for not paying their rent, sit down with your client and help them figure out if they can pay the outstanding amounts. They'll also need to pay their landlord's fees during the eviction process. If they think that they can make these payments, they might be able to save their tenancy. But this process involves a lot of complicated paperwork, so you should refer your client for legal advice as soon as possible if they decide that they want to fight the eviction. If the eviction is for anything else, refer them for legal advice immediately to see if there are any steps that they can take to cancel the eviction. If an eviction order isn't canceled and the termination date on that order passes, your client will be in step 5 of the eviction process, the notice to vacate. Remember, not all tenants will receive this notice, and the court enforcement office might just show up and evict them without warning. But if your client does get this notice, there's still some things that you can do to help them. The first thing you can do is help them call or attend at the landlord and tenant board to get any paperwork associated with the eviction. If your client wants advice on how they can avoid it, you can help them make copies of this paperwork and help them get legal advice immediately. Another thing you can do is review the notice to vacate with your client and help them prepare for the approximate date of eviction as it's listed on the notice. Remind them to collect any clothing, medication, and important documents ahead of time so that they have it on them on the date of the eviction. Once the court enforcement office or the sheriff changes the locks, your client will have 72 hours to remove their belongings. You can help your client make a list ahead of time of anything that they want to keep but that they can't necessarily carry, so that they can tell their landlord that they'll be coming back to get it. They should have this conversation with their landlord before the eviction. Those are some good examples of things that you can do to help a client throughout the eviction process. But there may be some additional things that you can do depending on the type of eviction your client is experiencing. So let's take a look at some common types of evictions and things that you can do to help. Let's start with evictions for not paying rent. If your client hasn't paid their rent or is behind on their rent payments, their landlord can start the eviction process one day after their rent was overdue. To do that, their landlord will need to issue them an N4 notice. This type of notice can be canceled if your client pays the amounts that are owed before the termination date listed on the notice. You can help your client by helping them figure out what they can pay and helping them prepare a repayment plan to give to their landlord. You can also help your client find financial assistance to help pay their outstanding rent, including through things like Ontario Works, ODSP, or local rent assistance programs. In some cases, your client's landlord might provide them with a repayment plan. If this happens, it's important your client reviews this plan carefully to make sure that they understand the terms. Because if they don't meet their obligations, or if they breach any of the terms under that plan, their landlord can evict them without notice and without a hearing. If your client does breach the terms of their repayment plan, you should refer them for legal advice immediately, because they could be at a high risk for eviction. Another type of eviction that you can look out for is a client who's being evicted for an illegal act on the property. This can be due to illegal activity within their own rental unit or within the residential complex, including places like common areas and other facilities that are open to all residents. This can happen to your client even if they aren't convicted of a crime, even if they have the charges withdrawn, and even if they were never charged in the first place. It can also happen if one of their guests commits an illegal act on the property. If your client's landlord wants to evict them for an illegal act, they'll need to use an N6 notice. If your client receives this, it's important that they get legal advice immediately, because there is no way to cancel this type of notice. Your client still doesn't have to move out if they don't want to, but their landlord can apply for an eviction hearing right away, and they can obtain an expedited eviction order, so it's important that your client get legal advice as soon as possible. The next type of eviction we're going to look at is an eviction for causing damage. How you help a client who's being evicted for this will depend on whether or not their landlord believes the damage was accidental or willful. If the landlord believes the damage was accidental, your client should have received an N5 notice. This notice can be canceled if your client repairs the damage or pays the amount asked for in the notice within 7 days. On the other hand, if the landlord believes the damage was caused deliberately, they will use an N7 notice. This is another type of notice that can't be canceled, so it's important your client get legal advice immediately. Your client still doesn't have to move out if they don't want to, but you should let them know that their landlord can apply for an eviction hearing right away, and they can obtain an expedited eviction order. So it's important your client get legal assistance as soon as possible. The last type of eviction we'll cover is an eviction that happens because a landlord says they, or someone else, is moving into the unit. This can be a family member of the landlord or another person if they've sold the unit. This type of eviction has become more common and is not always done in good faith by a landlord. If this is why a landlord is evicting your client, they should have received an N12 notice. You can let your client know that if they receive this type of notice, their landlord also has to give them at least 1 month's rent or an offer of another acceptable unit. However, if your client is concerned that their landlord is being dishonest with them about the reason for the eviction, you should refer them for legal advice. And just like that, we've covered eviction prevention. Until next time.